So good evening. It is now 7:03, and I'd like to call the August 30th meeting, the Newbury Conservation Commission, to order. Sam, could you read the remote opening meeting law preamble and take a roll call?
All right. As a preliminary matter, my name is Samantha Holt, Town Staff Conservation Agent for the Newbury Conservation Commission. Permit me to confirm that all members are present and can hear me. Conservation Commission members, when I call your name, please respond in the affirmative. Bob Connors.
Present.
Brad Duffin.
You're on mute, Brad. There you go.
No, I'm here, but you are breaking up. Everybody is breaking up. I don't know if it's my Wi-Fi because of the wind or what's happening.
I think it might be you because I'm not having any issues on my
Okay.
end.
I'll try moving to another remote spot.
All
Stand
right.
by.
All right. And Dan Streeter is not here yet. Diane O'Brien.
Here.
Mary is not here yet. Peter is not going to be joining us, and TJ Conti.
Here.
All right. Good evening. This August 30th, 2022 open meeting of the Newbury Conservation Commission is being conducted remotely, consistent with the act relative to extending certain COVID-19 measures adopted during the state of emergency, which extends the governor's March 12, 2020 order suspending certain provisions of the open meeting law until March 31st, 2023. This order suspends the requirement of the open meeting law to have all meetings in a publicly accessible physical location and allows public bodies to meet entirely remotely so long as reasonable public access is afforded so the public can follow along with the deliberations of the meeting. Please note that this meeting is being recorded and that attendees are participating by video and/or telephone conference, and the recording will be available on the Newbury Access YouTube channel. Before we turn to the topic of the agenda, permit me to cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. I will Bob will introduce each item on the agenda. For all attendees except commission members and staff, please remember to mute your computer using the mute button or on your phone using *6 to toggle mute and unmute when you are not speaking. Please use earbuds or earphones with tablets and cell phones. Please remember to speak clearly and in a way that helps generate accurate minutes. Please be aware that video participants can see you and that you should take care not to screen share your computer. Anything that you broadcast may be captured by the recording. Who did we just lose? We just lost Brad.
Brad might be going to sign back
Yes.
in, I think so.
All right. Please be, I already went through that. If commission members wish to engage in discussion with other members, please do so through the chair, taking care to identify yourself when you wish to speak. There will be a 1 hour public comment segment during this meeting. Members of the public will have 5 minutes each to address the commission, longer with the permission of the chair. I will display a timer for you on the screen. Please state your name and address for the record before proceeding with comments. For the purposes of efficiency, commission members shall refrain from responding to questions and comments from the public until the final segment of the meeting. There will be a 30-minute segment at the end of the meeting to allow commission members to answer questions and respond to comments. Please note that the chat feature has been disabled for this meeting. There's Brad. Please also note that everyone is expected to conduct themselves in the same manner they would at an in-person meeting. Any disruptions will be addressed once by the chair and must be acknowledged. Any further disruptions will result in complete removal from the meeting with no readmittance. Vulgar or obscene actions or comments will result in immediate removal from the meeting with no readmittance. And finally, each vote taken in this meeting will be conducted by roll call vote, and there should only be one, and that will be to close the meeting at the end.
Well, thank you, Sam. Excellent. So Sam, while we're waiting to see if anyone else is going to join us, could you give us a recap of where we're at, how many other workshops have gone on, obviously this being the 4th one?
Yes.
Give us a recap of where we're at.
So this is our 4th. Got one. This is Mary coming in right now. It looks like Dan is still having trouble getting in though.
Okay.
So yes, this is our 4th public workshop. And the first one we had was actually, it went pretty well. We had quite a few people come in and participate. That was very much mostly just to kind of get some kind of comments from the commission to see what the kind of driving force behind getting the bylaw amendment done was from the perspective of each member. We got a few questions and comments from some members of the public. The other meetings that we have had haven't been quite so exciting. We haven't really had any members of the public present for any of them. Mostly we've just been kind of working towards making revisions to the actual draft of the amendment, and kind of working through some different versions that we've had. Since I started, we've had maybe 2 or 3 different versions of it already that I've worked on. And we talked a little bit about some regulation development for the future, for after the bylaw, or if the bylaw gets passed. We've been working on, kind of going over some general, very broad stroke ideas of what kind of regulations members of the commission might want to see included once we get to that point where we're ready to be doing that.
Okay, thank you, Sam. Mary, welcome. All we did was open the meeting and do the preamble and spare you the boredom of hearing that for probably the 100th time. So
Thank you.
okay. So, well, good evening, everybody. Thank you for joining us. And why don't I just start in a general sense, and we'll do what we always do. I'll start. I have some opening comments, and then we'll just go right around to all the commission members for general comments, and then we can do a Q&A amongst ourselves, or certainly whatever direction the commission wants to go in. So first, I want to thank Sam and the current members. A lot of good work have gone into the whole workshop bylaw draft to date. And I mean, it's still work in progress, and certainly timing is important to roll out a successful bylaw and bring it to town meeting. I had a couple of questions, and I had questions sent to me. What's interesting, I had actually posted tonight's meeting on Facebook to 1,200 people, and I don't think I got, well, as of 5 o'clock, I didn't get anyone inquiring, and it was the flyer with the link and all that. So maybe the summertime barbecue and 90-degree weather is a little more exciting than probably chatting with us on a wetland bylaw. So there were 5 questions that were posed, sent to me, and that certainly a couple are my own. And I think they're basic questions, and I apologize. Some of these items may have been previously covered at earlier meetings, but I think it would be helpful to us to do a recap on it. And so the first one, demonstration and need, citing specific examples of resources being damaged or destroyed to an extent a more restrictive bylaw for work development currently allowed under the WPA or on the PI wetland bylaw is warranted. So do we want to go through my questions for, let me throw all my questions out and we can go back to them, or do we want to take them one at a time? And I don't want to monopolize this conversation either, certainly. So
Let's do them one at a time.
okay, thank you, Mary. So Sam or Mary, what examples have been made that demonstrates the need to be looking at a pathway towards a bylaw beyond what the state requires?
So the most the thing that comes most to mind is Cricket Lane, I think, because that was a situation where it was a new development. There was a resource that wasn't protected under the state law, the state rules, that had a vernal pool in it. And construction was very dense and proposed very close to this resource. And I was not able to participate in the discussion on this, but I know some members were very uncomfortable with the proximity of the work and the potential for impacts to a vernal pool, which is one example. I think that the need is to capture not only the resources that might not be covered under the Wetlands Protection Act that meet a certain minimum size criteria. And that is subject to debate. I think that, some of the towns have only, they're 500 or 1,000 square feet, which seems to be ridiculously small to me, but that's one of the issues, is capturing isolated wetlands. And the other important issue is establishing setbacks or minimum setbacks for new construction, where it would give applicants and the commission some kind of guideline for where to, what's an acceptable distance to the wetland edge without having to go back and forth, that it would be established. It could be overcome under certain conditions due to need or due to mitigation being provided in other areas of the site, but to have as a general guideline some sort of no disturb zone, essentially, that it does not exist under the state rules, and you can construct right up to the edge of a wetland, basically under current state rules. So in my mind, those were the two big items in capturing vernal pools, and also potentially in this capturing an ability to look at projects with longer term impacts in terms of sea level rise, climate resiliency, those kind of things, which may become part of the state regulation at some point, but is not right now.
Okay, so just so I understand, I want to do a recap. So basically, one of the drivers is vernal pools, isolated wetlands, setbacks within the buffer, and then exploring no build and no disturb zones within the buffer, which would not currently be regulated under WPA.
Right, and there, most of the towns around us now have bylaws or are bylaws pending, and they all have some sort of setback requirement built into them that is a guide, and they have, some are very hard and fast and some are not. Some are a no disturb zone and then a no build zone beyond that. But they all have that in common in establishing some kind of a no disturbance zone near the edge of the wetland. Okay.
Mary, thank you, Mary. Brad, do you have any comments or any feedback or any questions that might have been posed to you on this bylaw?
Your audio is not working, Brad.
Yeah, still not hearing anything, Brad.
We do have Dan coming in right now, though, just so.
Okay, great. Okay, Brad, why don't we circle back to you? I check your Wi-Fi setting and just make sure you're not like on Xfinity versus your home Wi-Fi. Calling in, gonna call in. Okay. Diane, any comments?
Are we talking that particular question or?
Yeah, I mean, you know what? I think Mary had a good idea. That was one question I've raised. Why don't we circulate that, and I'll hold my other questions, or the ones that was submitted to me, and let everybody, voice an opinion or introduce another question. So
Yeah,
on the demonstration of need,
on the demonstration of need, I had no questions at this point. I'm still trying to kind of get my head around,
Sure.
The entire process from the bylaw to then drafting the regulations and all that. So we can get to that in a bit.
Hey, Dan, good evening. Where we're at, we've opened the meeting, done the preamble, and we were just talking about a question, getting us up to speed on, there was a number of questions that, I have and some others that was sent to me and to others. On the first question was a demonstration of need. Mary has done an excellent job of bullet pointing vernal pools, isolated wetlands, setbacks within buffers regarding no build and no disturb in a general terms. And I was just going around asking for comments on that particular topic.
Yeah, well, I've kind of been going through this for a while, and
Sure.
I do think there's a need for the very things that you just mentioned. There's some difficulties in some ways to pinpoint how to add more protection for vernal pools. But there are certainly other towns that have been successful at developing ways to do that. So
Okay,
I'm good.
all right, thanks, Dan. TJ?
Thank you, Bob. Listening to Mary and Dan, I agree that there are some things that probably need some protection or some looking at. One of the things, though, that I was, when I first came on and asked why we're doing the amendments, the big reason I was told was that it will make it clearer for applicants to know what the process is going to be. So you read some of these and they need protecting, but I think they need to be worded and thought out so that it's clear to applicants, not making it just more strict and giving the commission more power to do what they want to do. It needs to be written so in a way that the applicant can know which way the decision should come. And there will always be some wiggle room in every project, but I think some clear definitions and clear projections are needed too.
Okay, thank you, TJ. Brad, I think Brad was calling in, Sam. It looked like Brad.
He came in and then left. It looked like he connected well and then just sort of dropped out. I think he's
Okay.
having some technical difficulties.
Okay, yeah, it's been a challenge getting on tonight, it seems. Sam, any other follow-up you want to add to the demonstration need beyond what Mary has said?
Yeah, I mean, I think definitely, the stuff that Mary outlined is definitely like a big part of it. And I think one of the bigger parts for me, I guess, is that it helps to provide some clarity, or the idea is that it would help to provide some clarity. And just to, kind of comment off of what TJ was saying, it's kind of a funky setup. So where the Plum Island bylaw has its regulations built into it, the inland bylaw, the inland section of it, would not necessarily have that. It would have, like, that's what would just give the commission the jurisdiction, and then the regulations is what would really provide that, solid foundation of, these are the guidelines, this is what we want to see, these are the rules that we want to have, which of course it would obviously be something that we really want, to get. That's kind of the big piece of what we want to get feedback on, I think, from people, because the bylaw gives the commission the jurisdiction, but the regulations, which is going to be a separate document, is what's really going to be the part that tells people what they can and can't do. And that's going to have ideally it's going to have really solid definitions in it, and it's going to be much clearer. The Wetlands Protection Act is vague on a good day, and it can be difficult to interpret. It can be interpreted in a lot of different ways. I know I've had in the last year some pretty intense conversations with people about, how the WPA is interpreted. And it's been some issues of, previous agents have interpreted it one way and the public interprets it another way. Individuals interpret it some way that's different. You guys might interpret it a different way. I might interpret it differently. So it makes it kind of tough. And ideally, the bylaw and the associated regulations will help to provide a lot of really good clarification for people, so that when someone comes in with an application, I can have a checklist of, did they do this, 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 and this? Yes, they did. Okay, they're all set. If they didn't, are they asking for a variance? No, they're not. This is a problem. You know, to kind of be able to work through that a little bit easier, hopefully, would be
I
great.
think we could I'm sorry to interrupt, but we could include the regulations in the bylaw if we
Yes.
chose to. But I think at a minimum, right now, we would need at least some definitions on any resource areas that are additional to the Wetland Protection Act. There needs
Right.
to be a definition. If we choose to provide protection for isolated wetlands, we would have to, I think, it needs to be upfront described in the bylaw. Same with vernal pools, so.
Okay, thank you, Mary. Brad, you, any comments on demonstration of need? I apologize, you've been dealing with communications, but. Okay, well, all right. Does anyone else have, I mean, there were 4 or 5 questions that were sent to me, but again, I don't want to overpower the meeting here. Anyone else have questions they want to interject beyond the first one here is on the demonstration of need? Or do you want me to continue down the list that was sent to me?
I think maybe you want to talk about whether there's anything in the town's master plan that would suggest that this is a goal of the town.
Yeah, no, that's a good point. That's actually one of the bullet points, Mary, that
That you had sent me, yeah.
yeah. So I think the 2006 Newbury Master Plan went into great detail, and it was in section strategy 4.5 and protecting the wetlands throughout Newbury. And I know that there's a committee now that's currently updating the master plan. I'm not sure where it's at. For some reason, I want to say that the last time I heard that they were hiring a consultant to put it in tablet booklet form or in final draft, but I don't know where that's at or what the timeline is on that. Does anyone else have an inkling on that? But there was a number of detailed items within that master plan that I mean, I think almost everyone you've mentioned, Mary, was recited in the master plan of 2006.
Pete may know about that.
Yeah. Pete's not on the call tonight. So Brad,
The other, just one other point in terms of the need, and it comes up sometimes, is to provide, and some people may think this is a good thing or a bad thing, but it provides another layer of appeal for someone who's not satisfied with the Conservation Commission's decision, which would require, instead of, what happens is that, you know, we make a decision and it gets appealed, it goes to DEP, and we're out of the loop. We have no more say on it. And oftentimes DEP issues an order of conditions that might, you know, have other conditions other than what we intended. Especially for large projects that are sensitive and that the town wants to have some local control over, it's helpful to have a local appeal avenue that is separate from DEP to retain some control through that process. So.
okay,
that's what I
thank you, Mary. All right, well, you know what? Why don't I get on my list?
I think
Mary.
Diane might
Diane
have
had a question. On
Oh, Diane, go ahead, dear.
Again, I'm all about the process. So Mary, like, what would the extra level of appeal be? So say we go and we get the bylaw in place, we get the regulations in place, and where's that extra level of appeal?
Sure. So you're essentially holding a hearing under 2 separate jurisdictions, the state regulations and your own. You combine the hearings into one. You issue an order of conditions under both, an applicant decides to appeal it, if they appeal the DEP, but they don't appeal the local bylaw as well, then they don't have all their approvals. They still have an outstanding approval that has not been resolved. The procedure for local appeal, the appeal of a local bylaw would be to Superior Court. And it would be a, unlike DEP, which does a de novo review, starts from scratch. It's like filing a new notice of intent with them. The bylaw appeal is based on the record, the written record, and whether or not the Conservation Commission followed its own rules.
So
But
then you could have, oh, excuse me, I'm sorry. You could have a situation where somebody gets the okay from DEP, but they don't get the okay from us. And then they would have to appeal that to the Superior Court.
right.
What would be the standard then? Is it arbitrary and capricious
Mhm.
on, that's the standard, which
I
is a
think so,
pretty,
yeah.
pretty high bar to meet on
Right.
a judicial appeal.
So in 99% of the cases, the decision will be the same, and most of our projects are approved one way or another. They can be conditioned in a way that they can be approved, but it's really intended for, often it's the larger, more controversial projects where it's helpful for the town to have a little bit more, in the aim in those situations.
Okay. All right, so the next item on my list was disclosure of impacts to property owners regarding potential costs for consultants, surveyors, and/or lawyers to comply with the proposed expanded jurisdiction, and certainly the complexity of the process. One of the questions is always, what's it going to cost me if I'm voluntarily going to give up and encumber my property beyond what I'm actually required to do now? Well, what's the cost? And
So there's no cost unless we decide that we want to have a filing fee. The forms are the same, that, the same engineering and survey and all those services are exactly the same. If you adopt the same procedures as under the state rules, we can adjust things like abutter notifications. Instead of 100 feet from the property, we can expand it to 300 feet if we wanted to. But the actual procedure for an applicant is exactly the same. And in most cases, the decision would be exactly the same. The only difference would be if, like I said, if there's an appeal, it would certainly, they'd have to, hire attorneys at that point. But there shouldn't be a cost. The burden is only if they choose to apply for a permit to do something on the property. So it doesn't encumber the property in any way prior to proposing to do anything. It's not even encumbering it at that point. It's just, they need to get a permit, a permission to do it.
so
So,
it,
and the number of properties that would be affected that aren't already covered under the Wetland Protection Act is probably very, very small.
so, but I think the question was more specific, Mary. It seems that almost every application that's come before the commission has hired a consultant presenting the case, surveyor giving, base flood elevations and surveys. And those are all impacts that people, the question was, if you don't have jurisdiction on my property now, and I agree to give you jurisdiction on my property that's not required at the state level, what could that cost me? And so I guess the question is, what's a typical cost now for an applicant to get a
Oh,
full,
that's what you're saying.
for an NOI? And I think the other thing, when you mentioned vernal pools, whether they're certified or who is going to certify it, I think one of the fears was the commission would be saying, you have to do the submittal, you have to do the engineer, all of the legwork on that. And what potential cost could that possibly run into? I mean, is it a $3,000?
It can be. I mean, it depends on the project and whether it's a request for determination or a notice of intent. But
Right.
frankly, it's the survey costs that tend to be the highest, and the engineering if it's required. But oftentimes you can get a survey plan with your addition shown on it and the wetland boundary shown on it, and that's, that's sufficient, and there's not a lot of engineering involved. But to get a plan that would, and we could theoretically have a lower threshold for plan requirements that were only filed under the bylaw. I mean, that's something that could be considered as well. It's just hard to,
I think people are just looking for,
yeah,
is the average applicant spending 2,500 or 3,000 now for an NOI?
Yeah.
Okay, and so I mean, I think that's a fair disclosure on what what the impact is, certainly depending on the complexity or how ingenious an applicant's going to be.
Right.
Okay, so the other thing was this, according to the most recent census, Newbury has about 2,650 households. We have 650 on Plum Island, covered by the Plum Island bylaw. The question recently asked, how many households will be affected in farms if residents volunteer to encumber their property beyond the WPA? All 2,000 or, so that, I think that was the thing that everyone understands, they're subject to the WPA at this point. But if we start impacting vernal pools, isolated wetlands, setbacks, if we expand buffer zones, I think is that one of the things that's had been considered, expanding buffer zones beyond the 100 feet? Okay.
no, but it's a good point. And I think that we can, with the aerial mapping that's available, that we can provide an estimation of how many properties, a lot of these, the smaller isolated wetlands, they may or may not show up on aerial, but it's a
Right.
pretty small number. They don't come up very often. I would say in my work, it's, I don't know, 20% of the time or something like that. There's an isolated wetland. It's not that often. There's an area that's not jurisdictional under the state rules.
Okay, thank you, Mary.
That's a rough guess there.
Sure. Anyone else? TJ, any comments, anything, any input you want to add?
Not in a general fashion like that. I'll reserve my thoughts for some specific things for later.
Okay. Brad, how about your thoughts?
Can you hear me?
Yes, we
Yes.
can, Brad.
Okay, great. No, I think that when you approached me first, I think the comment that we had on that property that Mary first started the conversation was Cricket Hill, I believe it was. It was my understanding that we were going to assume that any standing body of water was going to be designated as a vernal pool, even if it was not a certified vernal pool. And it was incumbent upon the applicant to prove that it wasn't, rather than relying on either the Conservation Commission or the DEP to designate it as a certified vernal pool. And then from the feedback that I got, those folks that reached out to me did say that they thought that that was too restrictive to putting that onus on the amount of engineering that would be required to go disprove that those were a vernal pool. We saw a protracted fight in that Cricket Lane applicant, as I recall, between differing opinions from an engineering firm that the applicant had hired versus a resident that had credentials that said that he was designated as a vernal pool. So I think that was somewhat confusing.
Yeah, that would, in that particular instance, if I could just, that no one argued that it was a vernal pool because there was evidence that it was a vernal pool. There was breeding activity in there. I think the applicant was trying to say it's not certified, and so you can't protect it. And that's what the issue was. And they were trying to say, look, we've got all this evidence, state, for whatever reason, didn't certify it. That's where it became a problem. But I agree that it can cause a lot of delays if you put it all on the applicant.
Yeah, I think that if I recall, Mary, that applicant was in that process for, and correct me if I'm wrong, I think it was around a year, because it had started well before that I got on the commission, and I think it was still when I
Yeah, it started
left.
during
for-
the ANRAD process, I believe.
Right, right. So, I mean, I can only imagine what now, sure, it was a big time developer that was just gonna bake that into the cost of their homes that they were gonna build in there. But on the other hand, if that had been an individual landowner who was looking to build and lack of a better, a compound for their family, there would have been significant amount of expense required, and that could transcend into other sections of the town. Maybe it's greater, maybe it's less than that 20% that you just quoted, but again, my opinion was that it seemed somewhat onerous in the fact that the wetland bylaw was going to be more restrictive than the current WPA.
The only cost involved in the vernal pool is analysis is for a biologist to be there at the right time and do the inspection and determine what's breeding in there, if there are frog egg masses. So it doesn't really require specifically engineering, but what it does end up is delay. So if you file in November, then you can't get an answer until April, and that causes a delay that way. And also, just quickly to point out, there's definitely a difference between an isolated wetland and a vernal pool, because they don't, a vernal pool can occur in an isolated wetland, but they don't have to. Isolated wetland does not have to have vernal pool within it.
And I think too that the intent wasn't to essentially force people to get those areas certified by the state. It was more that, where, for example, with Cricket Lane, we had all of this evidence, but that
Couldn't
just
act on it. Yeah.
screamed that yes, it's a vernal pool, it's serving as a vernal pool habitat. But the issue with the state certification was that they had repeatedly said, we want to see a study of how long, or we want to see proof that that area holds water for long enough. So the intent isn't necessarily to force people to get these areas certified, but to allow the commission to give them the jurisdiction to be able to say, we have now seen that, there's reasonable proof that there's, breeding activity, that it holds water for long enough. We've seen reasonable proof based on the state guidelines of what natural heritage goes through to determine a certification. If it meets those requirements, if it meets those guidelines, that the commission can kind of have the jurisdiction to say, well, we want to protect this because we've seen reasonable proof that it is serving as a vernal pool habitat. And then maybe, if you want to get it certified, go ahead and get it certified. But we want to see it protected as such.
Okay.
I get them, and I think that the point being was not that they get it certified, but that this wetland bylaw was going to assume just the opposite, that it almost automatically was going to be designated either one or the other. It was not to disprove it or require a applicant to get it, to get certification on an inland wetland or a vernal pool, but it was just the opposite. So I think that was the comments that I got back, that it was we already had that ability to say, if evidence is given to us, we don't need a wetland bylaw to say, you know what, looks like a duck, quacks like a duck, walks like a duck, it's a duck. We have that ability. And if somebody doesn't agree with that, then they can appeal that to the DEP. I think the other thing, from a personal perspective on this wetland bylaw, is that it locks our hands in maybe preventing us from approving a project that we may want to approve that is a good project. And for example, the duck blind that is it the Audubon or the Friends of
The trustees.
Trustees of Reservation? Well, under this bylaw, we'd have to completely say no.
Yeah.
And my perspective is the WPA gives us that latitude to use our good judgment, use evidence that's brought before the commission by either an applicant or a proponent against the applicant, to let us use our good judgment. And by having this wetland bylaw, I think that restricts our ability and then just becomes a rubber stamp no on
Right.
many
Hey,
projects.
team, I want to remind everybody, we got to go through the chair because I want to let everybody have a chance to speak. So Diane, do you have any comments or any wisdom you'd like to add to this discussion? At this
Definitely
point?
no wisdom,
Okay.
but the one thing that was occurring to me maybe a few minutes back was, and I had written just a few, I'm taking notes, that like right now we have the ability to sort of like rely on the state designations of the isolated wetlands and vernal pools and all that. So there's some protection from us in being able to do that. If we say it's not certified, or, you know, it's suspected or whatever, if we take on the jurisdiction to identify the isolated wetlands, and then if somebody, maybe that's exactly, I'm not familiar with Cricket Lane, but then if that is disputed, then does the town bear the liability, or we're the ones that are now in the position of, if they did appeal it to the Superior Court, is it up to the town then to defend us basically and our determination? And
That's an excellent question. Yeah, Mary, go ahead.
This is great discussion, so I'm glad we're having this. So the problem with those state regulations right now is that if you have a vernal pool in an isolated wetland, it doesn't get protected. Whether or not it's certified or not, it really doesn't have protection under the Wetland Protection Act because the resource that it occurs in is not jurisdictional. So we're trying to capture these areas that don't have state jurisdiction and are particularly sensitive because they may be vernal pools. The idea would be that it would be able to be regulated under the bylaw, whether or not it was certified. And documentation of it wouldn't require an applicant necessarily to certify it, but if somebody was on a site visit and they saw that it was a vernal pool, or Sam was doing a site visit, or you got information from neighbors or something during the process, it can come out that way. But to Brad's comment about the eliminating the possibility of doing good other projects, worthwhile projects, that's a really good point, and we can handle that through a variance procedure under the regulations or in the bylaw, where projects that have overriding public benefit these standards don't have to apply, or projects that have other mitigating measures, the standards don't have to apply to the same extent. But the idea is to provide an enhanced no disturb zone next to the most sensitive resources, which are vernal pools that are occurring in isolated wetlands that don't otherwise have protection. And then to the idea of appeal, yes, at some point, if it gets to that point, and it's pretty rare where you have a bylaw appeal, but it does happen, that yes, it would require that some town council involvement to support that, because you get involved with motions and cross motions and all that. But oftentimes it ends up being, if an applicant is appealing a decision that the Conservation Commission made, they're doing the bulk of that work and demonstrating that the commission acted arbitrarily and capriciously. But yes, there would still be some town involvement.
Okay, thank you, Mary. So Brad, what it seems to me, what one of your concerns you voiced was that basically we're this could put all of the responsibility on an applicant to identify isolated wetlands or vernal pools on their property that may not show anywhere else within a wetland map or other records of natural heritage. And so it's, if I understand what you were saying correctly, basically your concern was an applicant may have to prove that they do not have any of these components in order to proceed, on an NOI, RDA, or not file at all because we have no jurisdiction.
Yeah, yes, Mr. Chair, that sums it up pretty well.
Okay. All right, Dan, any comments you want to?
Well, I just want to go back a little bit. You were asking about costs and so on. I think
Right.
one thing that can be included is a waiver procedure for engineered plans. I've seen that in other towns. On the vernal pool thing, I think it's pretty complicated thing to try to get straightened out in your head. But Mary, correct me if I'm wrong, but if you do even have a certified vernal pool, it's only the portion of it that's in the wetland that is protected. Is that correct?
Only the portion that's in a jurisdictional wetland under the state rules, yes.
Right. So
Wetland
Yeah.
or buffer, the associated buffer around a wet.
It doesn't really extend the buffer.
No, but I'm saying if you have a vernal pool and it's not in the wetlands, but it's within the 100-foot buffer from of wetlands, we'd still have jurisdiction on that, wouldn't we?
Not under current rules, no.
Okay,
So that's
Right.
kind of the,
yeah,
it's complicated, but that, and the other thing I just wanted to mention was there is some ability to evaluate what might be a vernal pool uncertified, out of season a little bit. And, if you have, engineered plans, you're gonna have a wetland scientist already on the job. It's not very hard for them to just make a case, pro or con. We're convinced that this does not have any vernal pool habitat, no vernal characteristics. Yeah,
all right, thanks, Dan. Well, one last component that I wanted to interject was, certainly we have a lot of farming operations within Newbury. And I want to say that it's probably 20% of our, it's very enlightening when you read the master plan. It gives you a lot of information that sits on a dusty shelf most of the time, but when you actually dust it off, it has some great information. So farming operations, would they be exempt? Because farming is certainly the tilling fields. They can have standing water because of the nature of the porosity of the soils. Would it be something that we would consider existing farming operations exempting it from the bylaw? Mary, go ahead.
Yeah, so under the state regulations right now, agriculture is exempt. And, that was one of the things we discussed is carrying over all of the state exemptions to the bylaw. So that would be, because at one point we were talking even having agriculture be one of the protected interests of wetlands. So yes, I think that would be a good idea, in my opinion, to carry that exemption over, and that applies to, it's very specific what the definitions of agriculture, when you be selling a product and it has to be in agricultural use within the last 5 years. So, but if we carry over the same agricultural exemption, that should handle that.
Okay. TJ, I'm going to circle back to you. You had some questions that you've been patiently waiting to ask. So you have the floor, my friend.
Well, just a few, I don't think you want to go item by item. But in reading this, and I'm probably leaning more towards Diane's opinion about the process and the way everything is worded more than the actual, do we have the right to do it or not? But there seems like there's a lot of them that are leading to ambiguity rather than clearing them up. And one of them was what burden whose burden it was to prove or disprove some of those things we just talked to, but other things specifically, like when it talks about the historical buildings and whatnot, is there a list of historical buildings that can't be touched or that we have jurisdiction over already, and does that change? And
I believe that would be based on historic status, like a certified historic status. So like something like the Pink House, when they were coming through, they were in the process of receiving a certified historic status, which provides some exemptions. So historic buildings would be based off of
but they're not
Yes.
designated now, or are they?
Well, they were in the ACEC, so
right.
we had jurisdiction over that regardless of. I
Right,
mean,
so it doesn't necessarily remove jurisdiction, but it does allow for some exemptions to certain, performance standards and requirements and whatnot.
That was under
if-
FEMA though. Did we have something like that? I'm sorry, I interrupted.
Yeah, I
no,
don't
that's it.
think, there wasn't really anything in the way of exemptions or anything from the WPA perspective, but with FEMA, it was,
But it's not in our bylaw right now, right?
no, I don't believe it is.
Okay.
Yeah.
But the big exemption is that, like, and it's a big thing in Newburyport. I think when I talked to the building commissioner about it, he mentions like Water Street a lot, where there's so many houses that are in the 100-year floodplain, that when they do work on these houses and on these buildings, they aren't required to elevate them on pilings, because a lot of them have a historic status, so they don't
Right.
have to raise them on piling, similar to like what what you have to do on Plum Island if you're going to do over a certain percentage of the
50-50
50% rule,
Right,
where
right.
if you're going to go over that, you have to raise the structure on pilings for livable space.
Is that supposed to be in front of us, though? Isn't that more of a building and zoning?
It's not enough, that we're not making that.
Yeah.
Yeah,
No,
that's
I think it's important. I think it's important. This is still in the draft form. And so we're still brainstorming on all of this. But I think you brought up a good point, TJ. Any other points you want to bring up, TJ? Go through your list. You got the floor.
Okay, just in the notification where it's acceptable to hand deliver a public hearing notice. But it doesn't say whether you have to have proof that you delivered it to the owner, or just left it in the mailbox, or gave it to the wrong person.
That's a butter notification, that's from the state rules. That was
yeah, so
carried over.
and I believe the
Yeah.
state, and I don't actually, I've never actually read that, but I know that we had a situation where somebody way back when I first got here was trying to do abutters notifications and was really struggling with the process of getting those letters out. And he was allowed to, he got his certified abutters list from the assessor, and he actually went and hand delivered the letters to people's doors and got their signature on the abutters list, showing that he had been there, and got it all. He had them sign and date it next to their address so that there was proof. And that was how he proved to me that he did in fact provide the notification to them, provide the letter.
Okay. Again,
And
my
that
question was
is-
only back to clarification, because it doesn't say
Right.
that in the bylaw of how to
Right.
handle that. So just more things that need to be worked out. And let's see. Ultimately, they're all little things like that. Nothing huge, but a lot of little things that need to be spelt out better. So, as we work through it.
Yeah.
I'll let
No,
go.
I think a good point. Anything else, TJ, before we move on?
No, I'm good.
Okay.
And Brad has had his hand up a couple times, and Diane also has hers up now, but I know Brad looks like he's been waiting a while to make some
Is
comments.
that what those yellow spots are in front of
Yes.
Brad? Brad, go
Yes,
ahead.
Mr. Chair. So we did have a member of the public on, and have subsequently dropped off, but they did text me and wanted the commission, their comment was going to be, they did not understand why the Conservation Commission is working on a wetland bylaw when raw sewage is being discharged in the Merrimack River and landing right in their front yard here in the basin of Plum Island.
Unfortunately, that's not, and it really stinks to say it, it's not really anything that we can do about the sewer overflow issue is something that comes from the treatment plants in Haverhill and Lawrence and Lowell. I don't know if there's one in Lawrence, but it comes from those. And unfortunately, I believe those are state and federally regulated. Unfortunately, the Newbury Commission doesn't have any control over those overflow.
One point in it, growing up in the city of Woburn, DEP came in and put a building sewer tie-in moratorium. Well, we had an I&I infiltration problem, creating, and I'm going back in the 80s, and literally what DEP did is they put a complete building moratorium, all new tie-ins to the system until the problem was being addressed. And then there were all types of alternatives where a developer could come in and do a project, but he had to remove X amount, 2.5 times the gallons he was adding to the system as mitigation. You know, I wonder, not to get too far off the subject, but I certainly wouldn't have any problem reaching out to our elected delegation at the State House and saying, why in the heck are you allowing these communities to continue to tie in when they can't manage, you know, their current outflow?
I think that was their exact point. And I respectfully disagree with our conservation agent. I do believe that we have the ability to influence this tremendously. It's not just building here on Plum Island or building in Newbury, but I think that the Conservation Commission, as a sovereign town, does have the ability to influence and demand that it's not just Haverhill, it's not just Lowell, it's not just Lawrence, it goes all the way to Manchester, New Hampshire, and Nashua, New Hampshire, that continues to dump raw sewage, regardless of whether or not there's actually an overflow. I believe, because I've personally seen it as an active boater, I've seen during the tide change when Newburyport, who claims that their water is drinkable out of the treatment facility, the amount of actual raw sewage that is coming out right at the icebreaker. It is unconscionable for residents who pay a significant amount of taxes here in the town of Newbury to not have some relief from their local board. And that's the way that these people feel. And until a commission like us starts to focus on something as basic as clean drinking water, let's just talk about the damage that it's doing to the wildlife, the damage it's doing to the Great Marsh. This goes just way beyond Newbury. I'm fortunate enough to have a spot in Ipswich where this sewage makes it through the Plum Island River and down into Ipswich. So this is something that I believe, and at least the people that are texting me believe, that we have a say in. Maybe not the primary say, but we do have jurisdiction.
Brad,
That-
let me
that's all.
make, let me make a suggestion. Just because it's really not an agenda item tonight, but that doesn't mean we couldn't add it to the agenda of our next meeting on the last part of the administrative tab, Sam. If everyone thinks that's a good idea, I think we just plug it in there. I think it's a worthwhile discussion, and it simply is outrageous. And I totally agree. Diane, you've been waiting patiently. I apologize.
Well, I'm going back to the boring bylaw talk.
Well, I thought that might be why.
Okay, Sam, I congratulate you on everything you've done, as far as doing the multiple drafts and the marked up ones and the clean copies and, the proposed regulations and all this. I've been reading through it, and if I'm being honest, it's kind of the thing that keeps occurring to me is there's some other body, or does it just become cost prohibitive? Somebody that actually, writes these things. Are we just copying them from other towns? I mean, because if we can't get through the bylaws, almost when we get into the regulations and we're defining things and discussing, actually regulations, is there some other outside, I don't know if it's a law firm or town council or
Yeah.
whatever that would do this for us?
Yeah, so up until this point, what I've been doing, and I don't know, the proposed regulation topic didn't really come into play until honestly just the very beginning of this year, when we were kind of guided towards that by town council. She suggested that before we try to get the bylaw amendment into town meeting, that we start developing at least a draft of the regulations, just so that people can see this is what we are intending. So what I had been doing is I literally copied and pasted another town's, and I can't remember which town it was now, but I literally copied and pasted their set of regulations and went through it and tried to change it as much as I could see, as much as I could, to reflect Newbury. And that was, and I'm not an expert. I've never done anything like this before.
Right.
So it was a really rough start for me, but it's
Sam,
something
you're
that has,
doing an amazing job. But I think the point that Diane's making, I think we all know, we're going to need to
Yeah.
hire a consultant to, one, put this in final format, two, to actually, to cover the questions raised about the demonstration of need, the impacts, how far, the brevity of what this wetland bylaw could do. Merrimack Valley Planning, we're a member of that group. They do great work. We pay an annual fee. I know they have additional fees that they can charge on a project per project, but I would suggest to reach out to your town administrator and find out that I'll circulate this question, but I think that we want to find out what would be the process to reach out to get an outside consultant to help us address the questions and to finalize a wetland bylaw, so that when we go to town meeting, or even if we go to town meeting, we have all the answers covered, and it's in a format that we have a likelier rate of success than, say, what happened in West Newbury recently with a similar bylaw.
yeah, and that's something that's definitely, it's come up quite a few times since we started doing these workshops, that and one of the first workshops that we had, somebody had asked, what's going to be the cost to taxpayers to actually get the bylaw implemented? And generally speaking, there is no cost, because we're all, you guys are volunteers and we're the ones who create it and whatnot. But if we needed to hire a consultant, that would be a cost, but there's tons of grants and stuff that we can look into. And since it has been coming up especially in recent months, it's been coming up a lot more that, you know, we're kind of getting into stuff that maybe we need some help with, that I definitely think it's looking more and more worthwhile the more we talk about it, to consider applying for some grants to get a consultant to come in and help us out with some
Okay.
stuff.
So if you could
I think
reach out
Mary
to,
has some comments about
yeah,
that.
if you could reach out to Tracy about
Yeah.
the grants and hiring a consultant, and then we can go right around to the members just to see if we're all in agreement on that. Mary, why don't we start with you?
Yeah, no, I think that's a good idea. And also Mass Association of Conservation Commissions
Oh, yeah.
has they have a
MACC.
model bylaw, which all the other towns more or less model theirs on. And the way it's structured, there's certain basic decision points, you know, within it where you can tailor it to your town. And some towns have gone off and done their own with their own consultant and written it, you know, their own, and others have used consultants, but it's a good idea. And it, you know, I think it gives a taxpayer some level of confidence that it's been looked at. And that person can also look into how many properties might be affected directly by, you know, a change that would.
And I think that's always going to be the question at town meeting is this going to impact me and how many other people? The original wetland bylaw of Plum Island impacted about 500 properties in a very negative way. And it ultimately led to the repeal and replacement to the current bylaw. You know, and that's something certainly we don't want to repeat. And it seems our community gets a little more citizen petition oriented lately on these things. So I think it'd be worthwhile. Anyone not in agreement on going in that direction or have other thoughts? I'll start. TJ, I'm just seeing you at the
Yep.
next to Mary. Sound like a plan to you?
Absolutely.
Hey, Dan, how about yourself?
No problem with that. You know, I think we can get quite a ways without a consultant. I mean, I think we've come a long ways already, but no objection.
Okay. And Diane?
No, I agree. You guys have definitely come a long way already. And that was the thing. It was just a
Yeah,
matter,
lot
I
of hard
didn't
work.
quite
Yeah.
know what I was like looking at in the Dropbox and all that. So maybe just, and if it's presented at some point as, you know, the bylaw, I think the regulation should almost accompany it, just so you really have a sense of what the rules are going to be,
Package,
you know?
Yep. Brad, why don't you, we haven't, any comments on hiring consultant?
No, I think that Sam has done an amazing job, and she's downplayed her efforts so far, just saying that she had cut and paste. I think she's done a lot more than that. I have no issue with hiring a consultant or two.
Okay. Mary, back to you. Do you have any
Oh.
other point?
Sorry, I just kept my hand up.
No, yeah, I'm embarrassed to say, I was oblivious to these little yellow things on your, you're all the size of a postage stamp on my computer with all the files I have open.
Yeah.
Okay, so you know what, let me just see what else, and again, I don't want to, let's see here. So one of the things, and I think Sam and I discussed this, whatever gets presented to town meeting, we wanted to have overwhelming support. And I think this discussion and these points that we've raised tonight can go a long way that, you know, ultimately whatever is presented and when it's presented, we'll have the answers, and we can either alleviate the fears of people that it's 2,000 people better be prepared to spend $5,000 every time they want to paint the house, to it's really limited to this particular area, and it could impact 400 properties and not 2,000 additional properties. But so, I mean, I think that's basically, I think where what I had to bring up, and I had shared these notes with Sam and Mary earlier too, so I don't need to go too in depth on them at this point, I think. But.
And just, if I could just add one more thing, that
Certainly.
you have the ability, under these regulations, to have this potentially apply to only certain kinds of construction, new construction. Ipswich has different rules for houses constructed prior to a certain date. So I think that can also make people feel a little bit more comfortable, that it's not intended to just be a property grab or anything like that. And also, no one really likes to have regulations on their own property, but they very much like to have that when it affects maybe poor decisions of neighbors. So they like to be able to have something to fall back on, or to someone to complain to, that they can do something about if other people.
I really like that a lot, Mary, because I mean, if you have an existing home, you technically have some grandfathered rights to what you have, the components you have, and certainly treating that differently than new construction, where you have a clean slate. I think that's a very good point. It's a very good point, but. All right, TJ, any other comments? And then I guess we'll talk about next steps.
No, other than one little thing that I'm kind of going back to, but Mary, when you said we still have the right when it's regarding not just vernal pools, but wetlands, and Brad had brought up the bird watchers on Old Hill, saying that it can be overturned for public use, the overwhelming public use, letting us have the jurisdiction to say okay to that one and no to something else. But then that gets into what's important to who, and as a commission, are we deciding that watching birds is better than if they wanted to put guitar players and things like that? I don't want to get so specific or so ambiguous that it becomes just the opinion of 5, 6, 7 people on one board that determines what's good and what isn't.
Yeah. Well, TJ, I can answer that simply. We're going to be consistent in our approach to all applications. I think what Mary,
yeah.
What I think Mary was saying is there is a variance process for that gray area between the black and white that we have some latitude to address.
I think you're required, I mean, this ultimately, I believe, has to be approved by the state attorney general.
Right, yeah.
Right, so I think you're required to have a waiver provision. You can't just create
Right.
a setback,
Understood.
because that
No, I'm
becomes a
just-
zoning
Right.
change.
I'm just
essentially.
saying that
Yeah.
there can be a difference of opinion in what the benefit
Exactly.
is, the benefit
Right.
can be.
Right, so you'd have to be specific about what the benefit is if you're gonna be planting with native vegetation over an existing lawn, an area that's, over here, in exchange for being able to get an additional few feet for your new construction over here. That could be a trade-off that, we can describe. And the public benefits have to be like public health, safety, those kind of things. Those are,
And I think part of it too,
Emergency.
TJ, would be, if you've already get disturbed land or undisturbed property, there's a difference. As you mentioned on the back of Old Town Hill, that's completely undisturbed land. So that would draw, I think it behooves us to take a lucid look at it, just to fully understand how, access in, access out, like we do everything else, versus a house on High Road that it's completely landscaped in there, putting a side deck on, and it's in grassed area. I mean, it's already disturbed. It's still not, rather than undisturbed, but.
Yep.
That
was it.
Okay. Mary, you know what? Anything else you want to add, other than next step sounds like checking on grants and consultants to help the process?
sounds good.
Okay, Dan?
I'm all set.
Okay, Brad?
Thanks, Bob. Good.
Okay, and Diane O'Brien, Squire O'Brien.
I'm good.
Okay. All right, well, I think that's all we have for this part of the, our meeting tonight. So do we have any oral or written communications from members of the public, Sam? Is there anyone in attendance that,
I have not gotten any. Give me one quick second to make sure that I don't have anything old in the.
okay,
So usually I save, if I get emails from people, I save them into the folder in the Dropbox so I don't forget about them. The only one that I
Okay.
have is from Steve Mangin from back in October. So we don't have anything new.
Okay.
I would just like to say though that this has, I mean, so much new stuff comes in. I feel like we had, obviously, Ben and Brian they were great. They knew what they were talking about. But sometimes I think knowing exactly what we're talking about and having so many people who have all of this experience in, wetlands related things can almost be a bit of a downfall because, some of the big concerns that people have don't get addressed all the time. And I think having some new eyes on this and having, people who have a lot of similar questions that, don't have extensive backgrounds in wetlands protection and whatnot is so helpful in bringing to light some of the issues that haven't been caught previously. I think we definitely have a long way to go, but I think we're on a pretty good road at this point.
no, I totally agree. I mean, it's breaking it down so the average person understands what we're trying to accomplish, the need, and then what the impact, if any, may be on a majority of the residents or households in Newbury. So Sam, what I'm going to ask you to do, why don't you just put on the October agenda, just a little tickler on an update, how you've made out with where we're at on a consultant or getting what your town administrator talked to you about, gave you info on for the Merrimack Valley, or what types of grants might be available to assist the commission.
For
Yeah,
October or September?
Well, no, I don't think you're going to. I'd rather give you 60 days. You're not going to get any. You're not going to get back to us with anything that meaningful, I think, at that point. But and then put it on the agenda. Same thing. Let's put it on the last agenda item, administrative matters, like we've been doing.
Yep.
Okay.
And can I just, and I know we kind of chatted about this very, very briefly earlier, Bob. Do we have any interest in scheduling? I have the meeting schedule or a draft of the meeting schedule for the remainder of the year going through December. Do we have any interest in adjusting one of those meetings to be another workshop, or do we want to kind of get more solidified in a few things before we bring this back to another workshop?
Yeah, I think we have a number of open questions that it seems the next step is, I think a consultant will help carry the load for you. And you know what, if there's grant money available for it, there's no fall town meeting this year that I'm aware of. So
I don't believe so.
The earliest, if we're ready and we decide to go forward, would be the annual town meeting in
In
end of April. Yeah.
And we
end
would
of
have to
April.
have everything totally done and completely
Right.
ready to go by, I believe, February to be able
Right.
to get in on that.
Well,
which I
and,
have a feeling
and
is not
again,
super likely.
we'd have to be able to make presentations to the board of select, the
Right.
select board and what have you, and likely have an in-meeting workshop with people that people could attend. But I think that would be where I think we're at, though. Just give us an update, I think, Sam, on your monthly report or your meeting report at the end. And then it'll be the will of the commission, when we want to schedule the next workshop. But I think having some further information and some direction would be great. But team, that's all I have. I want to thank you all for all of your efforts to those of you that have put in a lot of time and energy to date, thank you. We all know in our different avenues of work and life, the amount of time and energy that goes into this. So please don't take constructive comments as anything other than that, trying to get this to a point that it has a reasonable likelihood of success when we bring it to the town meeting for town meeting consideration. If we have no further business, do we have a motion to adjourn the meeting?
So moved.
Most
Okay, so
second,
TJ made the motion, Brad seconded. Okay, all those in favor, say aye.
Hi.
Actually,
Aye.
I have to do a roll call
Oh.
vote, excuse me. Yeah,
Thank you.
okay, yeah, TJ. TJ, give us a thumbs up if you, if it's an aye.
Yes, yes.
Okay, Brad,
aye.
Dan,
Yes.
Mary,
Yes.
Diane,
Yes.
and the chair votes yes. Thank you, everyone.
Thank you.
Thank you.
Bye.
Have a good night.
Have a good night.
Bye-bye.
Bye. Thanks, Sam.